It is a legal term used to describe a witness who, by reason of his special training or experience, is permitted to express an opinion regarding the issue or a certain aspect of the issue which is involved in a court action. Do you think is the correct answer? Is it expert witness or ordinary witness? Look for keywords when you pick an answer. So, reason of his special training or experience and permitted to express an opinion regarding the issue. Do you think is the correct answer? Of course, the correct answer is expert witness. Okay. So in a court proceedings involving question documents, so a question document examiner is used, okay, to avoid reaching conclusions that are not supported by scientific evidence. Therefore, a question document examiner is presented in court because of his special training experience, and under our rules, he is permitted to express an opinion because of his special training or experience. Okay. So under the rules, we have two types of witnesses: expert witness and ordinary witnesses. So what is a witness? This is a sort of review under the rules of court. What is a witness? So under the rules of court, a witness, okay, are those persons who can perceive, and perceiving can make known their perception to others. So if a person who can perceive cannot make known their perception to others, then he cannot be a witness. Okay, very basic. And religious or political belief, interest in the outcome of the case, or conviction of a crime, unless otherwise provided by law, shall not be a ground for disqualification. Say, for example, if you're um, if you're a Catholic, you can be uh, disqualified as a witness. Okay, even if you're a Muslim or an Iglesia ni Cristo, is not a ground for your disqualification. Even your political belief, sa mga Lenny ba ka, or BBM, and interest in the outcome of the case, it shall not be a ground for disqualification. Even conviction of a crime, unless, of course, it's provided by law. Like, you're convicted of a crime involving moral turpitude, then you can be disqualified from becoming a witness for a while. Sorry for the background noise. And under the rules of court, we have this called opinion rule. So it's a well-settled rule under the rules of court that the opinion of a witness is not admissible except as indicated in the following sections, like opinion of an expert witness. The opinion of a witness on matters requiring special knowledge, skills, experience, or training which he has shown to possess may be received in evidence. Okay, his opinion may be received in evidence, like a question document examiner or a doctor, etc. Okay, as long as he has special knowledge, skills, or training. Okay. And next, opinion of an ordinary witness. So opinion of an ordinary witness, for which proper basis given, may be received in evidence regarding only to the identity of a person to whom he has adequate knowledge, a handwriting with which he has sufficient familiarity. So for example, kabalo siya sa agi sa iyang papa, sa iyang mama, okay, sa iyang friend. Okay, he's familiar with the handwriting of his friends, therefore he can be a witness. And also mental sanity of a person with whom he is sufficiently acquainted. For example, he can testify that Mr. A is sane, okay, because gakuyog sila for this past few months and he knows that dili insane si Mr. A. Okay, so he is acquainted for 3 months with Mr. A. Therefore, he can testify as to the mental sanity of Mr. A. Whether he is mentally sane or insane. Okay, so let's proceed. So it is a document which is executed by a private person without the intervention of a notary public. A basic question. A document which is executed by a private person without the intervention of a notary public. What do you think is the correct answer? Okay, of course, it's a private document. Okay, so as held in United States versus Orera, a private document is executed by a private person without the intervention of a notary public, by which documents some disposition or agreement is proved, evidence, or set forth. So as held in US versus Orera, a private document is a document executed by a private person without intervention of a notary public. Okay, and for commercial document, it is executed in accordance with the Code of Commerce or Mercantile Law, containing disposition of commercial rights or obligations such as receipts. Very basic. And a document executed by a private person with the intervention of a notary public. With the intervention of a notary public. What do you think is the correct answer? Is it a public document, private document, or official document? Of course, the correct answer is a public document. So under Catneo versus Baines, it was held there that those notarized by a notary public or competent public officials with solemnities required by law are considered a public document. Okay, Catneo versus Baines. Notarized by a notary public or competent public officials with solemnities required by law are public documents. Again, is public document, of course, is open to the public and it becomes part of public records and embodies the official act of a public officer. Embodies the official act of a public officer. Example, a marriage contract. How about official document? So they are public documents that are produced by virtue of office of a public officer. They are authentic. They are verified, such as NBI clearance or police clearance. Okay. Next question, a document defined and regulated by the Code of Commerce or any commercial laws. Of course, it's very obvious. Correct answer, commercial document regulated by the Code of Commerce or any commercial law. Next question, a deed of sale notarized by a notary public is an example of what document? Deed of sale notarized by a notary public. Matik, correct answer is public document. Okay. And a business receipt is considered as commercial document. Okay. A computerized document is an example of what document? Is it a document or an electronic document? Computerized document. The word computer, computerized. I think it's an correct answer is an electronic document. Okay, like emails. So by definition, an electronic document is a document received, recorded, transmitted, stored, processed, and produced electronically. Examples, emails are emails. They are considered as an electronic document. So this is new. A potential bird question. Hopefully. Next question is a private document, okay, which is more than 30 years old, produced from the custody in which it would be naturally found it as genuine. It's called is it a ancient document or contemporary document? Private document, 30 years old, more than 30 years old, produced from a custody in which it would be naturally found. The correct answer is ancient document. Okay, why ancient? Because by definition, an ancient document is a private document which is 30 years old and above and free from any dubious alteration. It's not altered. and found in the possession or safekeeping where the document is normally found, like our national archives. Okay, so under the rules, such a document is said to comply with the rules on evidence and definitely admissible in court. It can be accepted in court. Okay, so ancient document, it should be a private document, more than 30 years old, produced from a custody in which it would not be naturally found it as genuine, like the National Archives. Okay, and it is free from any dubious alterations. Free from any dubious alterations. So the correct answer is ancient documents. Now, what is a contemporary document? So these are documents which are not more than 5 years. Okay, not more than 5 years old. They are called contemporary documents. If more than 30 years old, ancient document, as long as it's private. Now, a 75-year-old holographic will is considered as ancient or commercial. What do you think? Ancient or commercial? 75-year-old holographic will. Of course, it's an ancient document because it's more than, right, it's more than 30 years old. Holographic will. And it's a private document also. Next question. It is a well-settled rule that an ancient document must be more than 30 years old. Okay, it's the rule. Therefore, public documents that are compiled in the Supreme Court since 1950 can be called ancient documents. What do you think is the answer? Is it true or false? Well-settled rule that an ancient document must be more than 30 years old. This is actually true. Okay, this statement is true. However, how about this statement? Therefore, public documents that are compiled in the Supreme Court since 1950s can be called ancient documents. What do you think is the correct answer? It's false. Why do you think the answer is false? Because an ancient document, mind you, okay, by definition, should be a private document, not a public document. Okay, see the difference? So ancient document should be a private document, which is more than 30 years old and above, free from any dubious alterations, and found in the possession or safekeeping where the document is normally found, like the National Archives or a safe. Okay? For example, na-safe ang usa ka tawo sa ilang balay, then dito nagibutang iya mga notarial will, mga holographic wills. Okay? Therefore, it's an ancient document as long as it's private. Private document dapat, not public document. Therefore, the answer is false. It is a document entirely written, dated, and signed by the hand of the testator himself. Is this a will or a holographic will? What do you think is the correct answer? Okay, what do you think is the correct answer? Roella. Is it will or holographic will or document? So the correct answer is it's a holographic will. Okay. Remember the two types of will. We have the notarial will or the testamentary will, and second, the holographic wills. Okay. So under our civil code, a person may execute a holographic will, provided that it must be entirely written, dated, and signed by the hand of the testator himself. It must be the three elements must be present, entirely written, dated, and signed by the hand of the testator himself. Okay, and it is subject to no other form and may be made in or out of the Philippines, and it not be witnessed. So it need not be witnessed. Dili require ang witness when you execute a holographic will, as long as it's entirely written, dated, and signed by the testator. Then how about notarial wills? What are the elements of a notarial will or testamentary will? So the will must be in writing, okay? Either printed or written, and then signed by the testator, of course, and signed by at least three witnesses. So a notarial will requires the presence of three witnesses. Okay, and in every page of the document, it should be signed, okay, and attested by the witnesses. And then lastly, it should be notarized. Okay, a notarial will, of course, from the word notarial, it should be notarized. So again, holographic document, entirely written, dated and signed by the hand of the testator himself, and need not be witnessed. No need ng witnesses. However, for notarial wills or testamentary wills, it should be in writing, signed by the testator. There should be at least three witnesses, notarized. Okay. So next question, a document which contains facts that may not be true or contested, either in whole or in part, with respect to its authenticity, identity, or origin. What do you think is the correct answer? I'm sure you can answer this. Of course, question document which contains facts that may not be true or contested, either in whole or in part, with respect to its authenticity. Keywords: authenticity, identity, origin. So therefore, the correct answer is question document. And a document disputed by one or more persons. Document disputed. Keyword disputed. Of course, correct answer is disputed document. Okay, so thank you everyone for listening. I hope you learned something from the Q&A discussion. Okay.